Hi, Bill Henshaw here again, continuing our introductory videos on our new YouTube channel, When in Court. Uh, and we're going to go into another area that you need to know about, which is how to deal with clerks of court. That's the first contact you're going to have with anybody on the other side, quote unquote, who should really be on our side, a story for a later video. But that said, this is a basic, simple matter that no serious discussion would be necessary if there were any state judicial courts of common law general jurisdiction in your state. But there are not any such courts, and for multiple compelling and unopposed reasons stated in my constitutional defense documents, information available at uwin@gmail.com. That said, today clerks of court in California have been ordered on who knows what authority not to file any documents presented by pesky pro per litigants, quote unquote, attempting to invoke rights secured by the Constitution for the United States 1787 to 1791, aka by the FBI as domestic terrorist, quote unquote, aka you. That said, you need to know that you must mail certified mail best, or take in person with a witness or two if possible, to the clerk of quote unquote court, often the traffic quote unquote court, or you can ask the county clerk to direct you properly to the office you have to go to. All of my 5 basic documents, after some light editing as noted in the instructions, and the notice of hearing date to be filed and a hearing date set for your motion to dismiss. Serve all copies of the documents on the local dais with the proof of service presented to the clerk for filing. This motion will not be opposed, at least not in the 4 decades I have been in the trenches. And this should lead to a dismissal of the charges, either on or more likely off the record. Think about this, and what fraudulently pretends to be the adversarial form of government which is supposed to exist, the dumbass has the sworn duty to sustain the government's burden of proof on at least jurisdiction and venue. If he cannot do so, or refuses to even make the effort, they ain't got any, and you win. Continuing with part 2 on filing your documents with the clerk of court, and you have to ask, what happens if your documents are not filed? You should firmly demand to see a supervisor, quote unquote court executive officer, or even the presiding quote unquote judge, because this is a clear and unambiguous violation of fundamental rights secured by the Constitution that even first-year law students would recognize it. Quote, parenthetically, as might a classroom full of my proverbial 4th graders, aka later as a jury of your peers. At some point, I would demand written copies of any and all authorities relied upon for this blatantly unlawful act. Parenthetically, we can get them later with subpoenas and thus discover the responsible party, a very difficult person to find in the government, which thinks that you have no rights which they are bound to respect. Subpoenas will be a subject for an upcoming video. This situation is precisely why I encourage ordering all of my constitutional defense documents initially, since you will then be prepared to file subpoenas as early as the next day, which will really raise a red flag and quote unquote encourage the bastards to make you go away by dismissing the charges. If the case continues, you are in a prime position to get some real answers, since my decades of research have not disclosed any way for a subpoena to be summarily dismissed without a hearing on the record. This means that the bastards must produce documents demanded, parenthetically, of which they do not have any, or must file a motion to quash or dismiss the subpoena, which must be filed, in which case your opposition to the motion to quash will contain every bit of ammunition in my armory of unopposed issues, which will now have to be decided on the record. Either way, your unopposed issues are now not only on the record, This will be the only record which contains any relevant admissible evidence for a jury to rule on in any subsequent litigation. This in a situation where the bastards will not have either anything remotely resembling an affirmative defense or qualified quote unquote, if not absolute quote unquote, judicial immunity. And this is the game changer for which I am in my 12th year all in and 4th decade overall of developing, since success here will mean a very nice payday, but more to the point, which includes changes in the way the system does business, with a lot more liberty and independence for you and for your posterity. And just remind listeners here to like this video, make comments, and you ought to love this one given information on it. Tell your friends and communicate with me at youwinincourt@gmail.com. I'd love to discuss it with you.